Welcome to Law Days and Lattes, the podcast where we blend the world of law and business with a warm cup of information and common sense. I'm your host, Sydney Whelan, attorney, real estate investor, and business owner. Each week, we'll be your go-to source for legal insights, business advice, and so much more. Whether you're a seasoned professional, an ambitious entrepreneur, or simply someone seeking guidance, we'll have you covered. From navigating the legal landscape to empowering you with valuable business strategies, we'll explore the legal side of life and enjoy a virtual latte along the way. So, grab your favorite latte, get comfortable, and let's dive into Law Days and Lattes. Hello, and welcome to Law Days and Lattes, sponsored by the Whelan Law Firm of Moberly, Missouri, where we help unravel and untangle the web of legal mysteries that affect your everyday life. I'm your host, Sydney Whelan. Today's episode is about what happens if you die without a will in Missouri. If you think this doesn't apply to you, think again. A staggering number of Americans don't have a will, and that can create chaos for the loved ones left behind. We're breaking down intestate succession, the legal rules that determine who inherits your property if you pass away without a plan in place. Spoiler alert here, the law may not divide things the way you'd want them to. Let's kick things off with a simple question. What happens when you die without a will in Missouri? What is intestate succession? That is the legal process of distributing a person's property when they die without a will. In Missouri, this process is governed by specific laws, and the probate court oversees it. Now, here's the key point. Not all assets go through intestate succession. Only property that's in your name alone at the time of your death is subject to these rules. For example, if you own a house jointly with your spouse, that property usually goes to the surviving spouse automatically. The same goes for life insurance policies or retirement accounts where you've designated a beneficiary. Those bypass the intestate probate process entirely. So intestate succession applies to assets like bank accounts, real estate, or personal property solely in your name. Let's take a closer look now at how Missouri divides those assets. The rules of intestate succession. Missouri's intestate succession laws follow a specific hierarchy. Let's break it down. First, if you're married but have no children, your surviving spouse will get everything at your death. If you're married with children and all of the surviving children are also children of the deceased spouse, your spouse receives the first $20,000 of your estate and half of the remaining balance. The other half goes to your children. If you have children from another relationship, your spouse will inherit half of your estate, and the children will inherit the other half equally. Next, if you have no spouse but have children at your death, your children or their descendants will inherit everything equally amongst the children. If there is no spouse or no children at your death, the decedent's parents, brothers, and sisters all share equally in your estate. If your parents are deceased, your siblings inherit the estate equally. But what if I have no close family, you may ask? Well, the law keeps going, looking for cousins, aunts, uncles, and other extended family members. If no heirs can be found, your estate is cheats back to the state of Missouri. So if you think dying without a will is a way to avoid probate planning? Remember, the state has a plan, but it might not align with your plan. So let's talk about the challenges of dying intestate or without a will. First, the probate process can take months or even years, depending on the size and complexity of your estate. This delays your loved ones from accessing what they need. In Missouri, a full probate estate can take close to 1 year to complete because of the timelines set out in the statutes. That is, if everything goes as planned and without a hitch. If there are any complications, it can take much longer. Second, family disputes are common. Without clear instructions, disagreements about who gets what can create lasting rifts in families. And third, the law doesn't account for special circumstances. For example, stepchildren. Many people don't realize that stepchildren are not automatically included under intestate laws. If you raised stepkids but haven't legally adopted them, they will inherit nothing at your death unless you specify it in a will. The same goes for unmarried partners or charitable causes that you care about. Those folks get nothing unless you specify it in a will or a trust. Finally, the burden of probate can eat into your estate. Between court costs, attorney's fees, and administrative expenses, less of your estate actually goes to your heirs. So, what can you do to avoid the pitfalls of dying without a will and your assets landing in probate? Step 1. Write a will. Remember, though, just a will without other estate planning will not keep your estate out of probate. But it's the simplest way to ensure that your wishes are honored. Even a basic will can make a world of difference. And remember, if you have minor children, your will is the only place that you can name a guardian and conservator for your surviving minor children. Step 2, review your beneficiary designations on life insurance, retirement accounts, bank accounts, and titled motor vehicles. These take precedence over your will and will pass directly to your beneficiaries without going through the probate process. Step 3, consider more advanced tools like trusts. A trust can help you avoid probate entirely and provide even greater control over how your assets are distributed. Trusts work by creating a separate entity to own your assets. When created and funded correctly, you will not own any assets solely in your name at your death. Those assets will be owned by and distributed through your trust, eliminating the need to open a probate estate to administer your assets at your death. Instead, you will have appointed a successor trustee to distribute your trust assets according to your wishes, entirely outside of probate court. Step 4. Update your estate plan regularly. Life changes like marriage, divorce, or having children should prompt a close review of your estate planning documents. And of course, work with a qualified estate planning attorney. The experienced attorneys and staff at the Whelan Law Firm in Moberly, Missouri will help you navigate the legal complexities and tailor a plan that fits your needs. Contact us anytime at whelanlaw.com or by phone at 660-372-2152. Before we wrap up, here's the bottom line. If you die without a will, Missouri has a plan for your assets, but it may not be the plan you choose. Take control of your legacy, draft a will or a trust, update your beneficiaries, and consult with an expert. It's one of the best gifts you can give your loved ones. Thanks for tuning in to Law Days and Lattes. If you found today's episode helpful, please subscribe, leave a review, and share it with someone who might need this information. If you have questions or want us to tackle a specific topic, reach out to us on social media. We would love to hear from you. Thanks for listening. And as always, my friends, grab your favorite latte, hold your loved ones tight, and have a great week.
This podcast episode contains general information for discussion purposes only. Each case is different and must be judged on its own merits. Missouri rules generally prohibit lawyers from advertising that they specialize in particular areas of the law. This show should not be construed to suggest such specialization. Nothing on this show should be taken as legal advice for any individual case or situation. This information is not intended to create an attorney-client relationship, and the listening or viewing of this podcast does not constitute an attorney-client relationship. The choice of a lawyer is an important decision and should not be based solely upon advertisements.